Dear students, subscribers, and the viewers, welcome to the IAS Mentor. This would be our lecture number 106 in the series Indian Polity. And in this lecture, I am not going to discuss a particular topic, but what we are going to discuss is we are going to do the practice questions. I have already said there are three important pillars to your success. One is you should have the conceptual clarity in all the subjects, not only in Indian polity. Then you do regularly practicing the questions. It can be the multiple choice questions or it can be previous year questions. And apart from that, you should also do a regular revision. And in fact, doing revision and doing questions are complementing and supplementing one another. And if you keep doing these simple things, and I'm quite sure that your success will be assured. You're not complicating your preparation process. And to be successful in a very complex examination, you should try to simplify it as much as possible. And provided you need to know what you should do and what you should not do. So that's again very, very important. So you can reach out to any of the candidates who already cleared the examination, or you can trust any of the mentors whom you think that they can help you, but someone who is well aware of this particular process. But however, as I already said, one of the most important thing to clear this examination is consistently doing the practice questions. And that is the reason why after every substantial topic, we are also doing the practice question. So today in this lecture, we are going to do some practice questions from two topics, that is center-state relationship and the local bodies, that is the Panchayat and the municipalities. So we have completed the Panchayat and municipalities in the last class. So we'll try to do the practice question, and thereby we'll also revise our concepts. So students who are watching this particular lecture, I would suggest them to watch the previous 4-5 lectures before you watch the practice questions. Because without knowing the concepts, if you come and do the practice question, it is not of much use. But once you cover the area, then you do the practice question, it can really help. All right. So with that, let's just go to the first question as to what you have to discuss. Consider the following statement. Statement 1. The Rajya Sabha alone has the power to declare that it would be in national interest for the parliament to legislate with respect to a matter in the state list. We have seen under the schedule 7 of the constitution, there are certain areas where it is only the power of the parliament, especially what is in the union list. Whatever is in the state list, normally it is the power of the state legislature. Whatever is in the concurrent list, both the parliament and the state legislature can make laws. But however, one important thing that you have to remember is, even on an item in the state list, under certain circumstances, the parliament can make a law. And one such article that is giving the power to the parliament is Article 249. But under Article 249 of the Constitution, for the parliament to exercise its power, first a resolution has to be passed by whom? A resolution has to be passed by special majority by the Rajya Sabha. And the special majority here is 2/3 of, not less than 2/3 of the members present and voting. So therefore, unless and until with this special majority, a resolution is passed, only after the resolution is passed, then only the parliament can make a law. And without this resolution, the parliament cannot make a law. So statement 1, the Rajya Sabha alone has the power to declare that it would be in national interest for the parliament to legislate with respect to a matter in the state list. So this is definitely true. The second statement is the resolution approving the proclamation of emergency are passed only by the Lok Sabha. So we have seen under Article 352 of the Constitution. Under Article 352 of the Constitution, the President can proclaim the national interest. But once in national interest, the proclamation is proclaimed by the President of India, then subsequently, this proclamation of national emergency has to be placed for the approval of both the houses of the parliament. And both the houses of the parliament has to give the approval within a period of 1 month. So the approval is required from both the houses of the parliament by special majority. So therefore, to say that only the Lok Sabha will approve, this is a wrong thing. So therefore, this particular statement is wrong. So which of the statements given above are correct? The right answer is option 1 only. So 1 only is the right answer. All right. So please come to question number 2. The parliament can make any law to all or any part of India for implementing any international treaties. Is it possible? Even if an item is related to the state list, is it possible for the parliament to make a law in order to implement any international treaties? That is very much possible for the parliament to make a law, even if it is a subject matter related to the state list, but however, in order to give an effect to an international treaty without the consent of the states. In fact, to make this law, the parliament does not have to take any permission from the states or from the state legislature. So therefore, what is the answer here? With the consent of the states, with the consent of majority of states, with the consent of the concerned state, no, without the consent of the state. So therefore, the answer is option D. So both these questions are related to center-state relations. Come to the next question. The Parliament of India acquires the power to legislate on any item in state list in national interest if a resolution is passed to the effect by what? So this is again related to Article 249 of the Constitution. Just now we have discussed. Under Article 249 of the Constitution, the Rajya Sabha can pass a resolution, and whenever this resolution is passed by Rajya Sabha, this resolution is normally in force for 1 year. So how long this resolution is valid? This resolution is valid for 1 year. Within this 1 year time, the parliament can make a law. And once the parliament make a law within the period of 1 year, as long as the resolution is valid, that law can continue to be in force for another 6 months after the resolution is expiring. So therefore, this law is not a permanent law. This law is only a temporary law which is made by the parliament under Article 249 of the Constitution. But the primary condition is the Rajya Sabha can make such a law only on the basis of a resolution that is passed by the concerned state legislature. Sorry, resolution that is passed by what is called as the Rajya Sabha. So the Rajya Sabha resolution is imperative for the parliament to exercise its power under Article 249. And what is the majority with which the Rajya Sabha has to pass a resolution? The Rajya Sabha has to pass a resolution with special majority. And what is that special majority? The special majority is not less than 2/3 of the members present and voting. 2/3 members present and voting. So this is what is important. Lok Sabha by a simple majority? No. Lok Sabha by a majority of 2/3 of the members? Not Lok Sabha. Rajya Sabha by a simple majority is also wrong. Rajya Sabha by a majority of not less than 2/3 of its members present and voting. So the answer is option D. Okay. Please come to question number 4. Which one of the following is not a feature of Indian federalism? So when you talk of federalism, there is something which is called as division of powers. Division of powers between the center and the states. So whatever provides for division of powers between the center and the state, then you can call that to be the federal provision. So here it is asking which of the following is not a feature of federal provision. There is an independent judiciary. Does the independent judiciary safeguards of federalism? Of course, very much. An independent judiciary safeguards of federalism. And how do you think that the independent judiciary safeguards of federalism? As long as a judiciary is independent, if there is any dispute between the center and the state, the judiciary can pass a fair judgment. So therefore, to that extent, the judiciary has to be independent, and an independent judiciary is very, very essential to protect the federalism. So therefore, to say it is not a federal feature, this is wrong. In fact, it is a federal feature. The powers has been clearly divided between the center and the state. That is also true. It is part of the Indian federalism. The powers has been clearly demarcated in the Constitution. Don't think that more powers has been given to the center and less powers has been given to the state. That is true. But whatever power that is given, that is clearly given in the Constitution. So therefore, it is a feature of Indian federalism. So therefore, this cannot be the answer. The federating units, that is the states or the federating units, has been given unequal representation in the Rajya Sabha. This is also true. In the kind of federation that you have got in India, the states do not have the same representation. Different states are having different representation in the Rajya Sabha. And the representation in the Rajya Sabha depends upon the population of that particular state. Uttar Pradesh has more representation, but most of the northeastern states have very less representation, but it is on population. So this is also true as a part of our federation. It is a result of agreement among the federating units. No. When the Indian Federation was formed, when the Constitution of India came, it was not an agreement between the union and various states. No, nothing of that sort has happened in our political history. So that is why we say that the Federation of India is more a holding together federation rather than a coming together federation. So this is true in relation to the Federation of United States of America, which is a coming together federation, a federation that resulted as an agreement of number of states. But that is not true with regard to India. So therefore the answer is, which of the following is not a feature of Indian federalism? The answer is option D. It should be very clear in your mind. So alright, so this also is completed. So please come to the next question, that is question number 5. Consider the following statements. Under the Constitution, the center can give directions to the state to ensure compliance with the law made by the Parliament. So if you look into article, so this is related to article 256 of the Constitution. So if you look into article 256 of the Constitution, which talks about the executive power of the Union and the states, article 256 of the Constitution makes it very clear the executive power of the Union shall be, or in other words, the executive power of the state has to be exercised in such a way that it ensures compliance with the law made by the state legislature, and it also ensures compliance with the law made by the Parliament. And suppose if the state is failing to do that, then the Union can give directions to the state to ensure what is called as compliance. So therefore this particular statement is true. Under the Constitution, the center can give directions to the state to ensure compliance with the law made by the Parliament. Statement number 2, the states must share their revenue with the center as per the recommendation of the Finance Commission as per the Constitution. It is not necessary for the states to share their revenue with the center, but it is mandatory for the center to share their revenue with the states. And to what extent the center will share their revenue with the state? It is for that purpose, under Article 280 of the Constitution, the President can appoint what is called as the Finance Commission, which I will subsequently discuss. We have not seen the constitutional bodies yet. So I have given a brief idea about the Finance Commission when I was discussing about the center-state relationship. But however, when I take up the constitutional bodies, I will talk completely about the Finance Commission. But however, this was not true. So which of the statements given above are correct? So definitely 1 is correct, but not 2 is correct. So therefore the answer is 1 only. So option A is the answer. Please come to question number 6. As per the Constitution of India, 2 or more states can request the Parliament to make a law on an item in the state list by passing a resolution in the state legislature concerned. Is it true? Yes. As per Article 253 of the Constitution, this is possible. As per Article 253 of the Constitution, this is possible, where 2 or more state legislatures can pass a resolution. How many state legislatures have to minimum come together? Minimum 2 state legislatures have to come together. So when 2 or more states pass a resolution asking the Parliament to make a law on an item in the state list, then the Parliament will make a law on any of the item in the state list. But at least minimum 2 state legislatures have to pass this resolution. And what is the majority with which the state legislature have to pass a resolution? By simple majority. Now once a law is made by the Parliament, that's a permanent law. That means in the future, if at all the law is to be amended or if the law is to be repealed, it can be only done by the Parliament and not by the state legislature. But however, this does not prevent the other states from adopting this law. If apart from the original states which has passed the resolution, if other states also wanted to have this law, they can pass a resolution and they can directly adopt this particular law. That is also done by a simple majority. So what is the answer in this case? It is a simple majority. The answer is option A. So that should be quite clear to all of you. So please come to the next question, that is question number 7. Which of the following is true regarding the grant in aid that is given by the center to the states allowed under Article 275 of the Constitution? As per Article 275 of the Constitution, the center can give some grant in aid. So grant in aid is usually given by the center to meet some special requirements of the states. It is given not to all the states, it is given to certain specific states where the state needs these grants. Maybe the state is very backward, the state has lot of tribal population, the state has certain special issues. So to address all those things, the center may give certain grant in aid, which they don't have to pay it back. So such grant in aid may be given to the states. Now there is a provision under the Constitution, that is Article 275, which allows the center to give this aid to the states, which is usually done on the recommendation of the Finance Commission. But however, there are certain other constitutional dimensions we will have to remember with regard to Article 275. It is a statutory grant. Is it a statutory grant? Whatever grant that can be given by the center to the states by virtue of Article 275, it can be given only by enacting a law. So it cannot be just given without by an executive action, but it requires a law to be enacted by the parliament, and by that law they can transfer this particular grant to the states. So therefore, to say whether it is a statutory grant, it is true. Whatever grant under Article 275, it is only a statutory grant. And whatever money that is to be transferred from the center to the states in the form of a grant, that has to come from the Consolidated Fund of India. And the expenditure that can come from the Consolidated Fund of India can be either a made expenditure or a charge expenditure. So what is the difference between a made expenditure and a charge expenditure? A made expenditures are those expenditures which are put to vote in the vote on demand for grant stage. But whereas what is a charge expenditure? A charge expenditure is something which may be discussed but not put to vote. These are all considered to be very important expenditures. So therefore, if you look into the constitution, any grant in aid that may be given by the center to the states under Article 275 is not only a statutory grant, but this expenditure is considered to be a charged expenditure and not a made expenditure. So therefore, statement 3 is wrong. The grants are made from the Consolidated Fund. No, it is charged from the Consolidated Fund of India. Choose a correct answer from the codes given below. So the correct answer would be option C, that is both 1 and 2 only. So this is something that you'll have to keep in your mind. Alright, so please come to the question number 8 of the discussion today. Question number 8 is talking about Article 266 of the Constitution. Article 266 of the Constitution talking about 4 funds. What are all the funds that can be established under Article 266 of the Constitution? Article 266 of the Constitution talks about establishing the Consolidated Fund of India and of the states. While India can establish its own consolidated fund, and the various states, they can have their own consolidated fund for their respective states. Article 266 also allows for establishment of public accounts of India and the public accounts for each and every state. But Article 266 does not talk about what is called as the contingency fund of India or of the states. The contingency fund of India and for the states, it is mentioned only in Article 267, not in Article 266. So therefore, contingency fund of India and states is wrong. So 1 and 2 is right. So choose the correct answer from the codes given below. It is 1 and 2 only. Okay, now of all the 3 funds, the Consolidated Fund of India, the Public Accounts of India and the Contingency Fund of India, in one case, to take out even a single rupee out of all the 3 funds, every time it requires approval of the parliament. So can you give me the answer out of the Consolidated Fund, Contingency Fund and Public Accounts of India? To take out money from which of these funds, it requires approval of the parliament in the form of an appropriation act. Please put your answers in the comment box. Alright, so with that, please come to question number 9. Which one of the following which one of the following authorities makes recommendation to the governor of a state to the principles for determining the taxes and duties that may be appropriated by the parliament in that particular, appropriated by the Panchayat in that particular state? That means which one of the following authorities make recommendation to the governor of that particular state to make finances available to the Panchayat in that particular state? So who will do that? It is not the district planning committee. Anyways, district planning committee is only provision related to the municipalities. It is not the finance ministry of that particular state. It is not the Panchayati Raj ministry in that particular state. It is the state finance commission. It is for that particular purpose the governor has to appoint the state finance commission. We already seen that. In fact, the 73rd Constitutional Amendment Act says 1 year after the 73rd Constitutional Amendment Act was introduced, then within 1 year in every state there should be a state finance commission which is appointed by the governor. And thereafter every 5 years a state finance commission has to be appointed by the governor. Their membership and their qualification will be determined by the law that is passed by the concerned state legislature. So the answer in this case is option B. B is the right answer. If a panchayat is dissolved, the election shall be held. So normally whenever a panchayat is prematurely dissolved, we have seen that the election should happen within a period of 6 months. And if any panchayat is prematurely dissolved and the newly elected panchayat is only for the remainder of the term and not for a full 5-year term, so therefore the answer in this case is 6 months. C is the right answer. So I'm sure that till this point of time you have a good conceptual clarity. So come to the next question, that is the 73rd question number 11. The 73rd Constitutional Amendment Act 1992 refers to what? So what is the basic objective, or what is being provided by the 73rd Constitutional Amendment Act? Generation of gainful employment for the unemployment and underemployed men and women in rural India. So this is not related to the 73rd. It's not a major objective. It can be a part of it, but that's not the major objective. Generation of employment for able-bodied adults who are in need and desirous of work during the lean agriculture season. No. So that is also not the right answer. Laying foundation for strong and vibrant Panchayati Raj institution in our country. There's a big yes to option C. Anyways, come to question number D. Guarantee right to life and liberty. So it is not related to any of the fundamental rights. It is giving a constitutional status to the Panchayati Raj institutions. So therefore, the right answer is option C when it comes to question number 11. Come to next question. What is the system of governance in Panchayati Raj setup? So what is the structure of the Panchayati Raj setup? Single tier structure? No. Two tier structure? No. Three tier structure of local government at the village, block and the district level. That is at the village, at the Samiti, that is the intermediate level, and also at the Zilla Parishad level. So therefore the right answer is option C. So it is not providing for any 4-tier structure. In fact, after the 73rd Constitutional Amendment Act, this is a mandatory provision. So this is mandatory that there is an uniformity of structure in all the states with regard to Panchayat. So this is definitely there. So therefore, for the question number 12, the right answer is option C. Alright, so please come to the next question. Who shall constitute the Finance Commission as per the Constitution? Just now we have seen that after the 73rd Constitutional Amendment Act, within a period of 1 year, the governors of all the states have to establish the State Finance Commission. And thereafter, every 5 years, the governor shall appoint what is called as a State Finance Commission. So this is exactly what you already learned. So therefore, you'll have to be clear about this. But however, who shall determine their composition and the qualification of the members appointed to the Finance Commission? All those things can be done by the law passed by the concerned state legislature. But the appointment is done by the governor. So therefore, the answer is option C. Come to the next question. I think we are in the second last question. There's one more question. We'll complete that. The local self-government can be best explained as an exercise of local self-government has nothing to do with federalism. It's a third-tier government. It is nothing related to federalism. It is nothing related to administrative delegation. It is not related to direct democracy. It is not the people themselves will decide. In the local government also, the people elect their representatives. So, most importantly, you are bringing the system of administration to the lowest level, to the grassroots level. So, it's an example of what is called as democratic decentralization. So, therefore, the right answer in this case is option B for question number 14. Come to the last question. I think this is the last question for the day for this particular discussion. So, come to the question. The Constitution 73rd Amendment Act, which aims for promoting the Panchayati Raj institutions in the country, which provides for following. That means which of the following are the provisions of the 73rd Constitutional Amendment Act. First is Constitution of District Planning Committee. Now, the District Planning Committee is part of the 74th Constitutional Amendment Act, or it is part of the municipalities. It is not part of the Panchayat. So, therefore, this is not the right answer. The next thing is the State Election Commission to conduct all the Panchayat elections. Is it true? Yes. The 73rd Constitutional Amendment Act has provided for a system of State Election Commission, in fact, to carry out election to the Panchayats. Establishment of State Finance Commission is also allowed under the 73rd Constitutional Amendment Act. So, therefore, what is the answer? The right answer is option 2 and 3 only. So, now we have discussed 15 questions. So, but if you see, for every 3 to 4 lectures or every 5 to 6 lectures, after a substantial amount of portion is covered, we are doing one practice which may contain 15 questions, sometimes 10 questions, sometimes 20 questions. But these revisions are very, very mandatory to test your knowledge. And if you are able to do maximum of these questions, right, I'm not saying that you will not make mistakes. You will make mistakes, but that is the way that you can learn from these mistakes so that we do not make mistakes in the actual examination. So, practice is very, very important. If you have any questions related to any of the questions that I have discussed, any of the lectures that is there in the series, or in general related to the preparation, you can reach out to me. You can think me as your guide, mentor, or a friend, whatever it is, but don't hesitate to reach out to me. If you like this video, please share it with others for whom it may be helpful. So thank you very much and all the very best.